Good morning to all of you. Welcome to Legal Matters by Sai Baba Sankara. This is for Law of Tort students. Good morning, friends. Today we are going to discuss the real tort, that is specific tort. As you all know, the torts are committed in three varieties. Now, one, against a right to personal safety, or right to person we call it as. So that means a person should be free, a person should be safe. If somebody attacks him, if somebody thrashes him, if somebody keeps him in confinement, come on, you should not move out of the room, or somebody files a case against him, false case. These are all called as trespass against person. They are specific torts. If you are able to prove that yes, this man has shown force, then definitely you are liable under tort. So, till now we have discussed just the basic principles or the concepts. Who is liable, who is not liable, what is absolute liability, what is strict liability, what is the vicarious liability, and what are the defenses, general defenses. All these things we have discussed. Now we are coming to the specific tort. So, right to personal safety. This is topic. Second one, a right to property. So everybody you have got right when you are the owner of your property. Then if anybody trespasses, if anybody damages, if anybody meddles with your property, that is a separate chapter. And third, right to reputation. Right to reputation. Everybody has got reputation. If that is the defamed, then defamation cases will come. So, as far as today's topic is concerned, we are dealing with the specific torts, that is trespass to person. So what is this trespass? Trespass means, please remember, ingressing into another's property, ingressing into another's person or property. So doing something wrong. Normally the word trespass will be used in case of property only, but since it is an old tort law, that too, your students, so I am telling you, in English law, in common law, it was known as trespass to person. So what are these trespass to person? There are 4 types of trespass to persons. Number 1, assault. Number 2, battery. Number 3, false imprisonment. And of course, number 4, that is malicious prosecution. Sometimes it may come under defamation also. These 4 things are important if you learn. So, at this outset, I want to tell you that this assault and battery, malicious prosecution and false imprisonment, all of them can be used as crimes also. You can file a case against them as crime also. But when tort and when it becomes a crime, already in the beginning stage I told you, tort is a civil wrong, crime is a public wrong. It is a social wrong where the person will be punished, sent to jail. Here only compensation will be given. Is it not? Right. So it can be used as a crime also. Therefore, you know the sections, that is 319 of the Indian Penal Code, 340 of the Indian Penal Code, what is force, all these things I have given in my notes. Please look through them. Right. The first one is assault. Assault can be used as a crime as well as a tort also. As far as the tort is concerned, assault is simply to say it is a show of force which creates an impression in the mind of the plaintiff that you are going to use force against him. ఇది షో ఆఫ్ ఫోర్స్. ఎలాగా? ఎదుటి మనిషి అయ్యో వీడు మన కొట్టబోతున్నాడు అని అనిపించాలి. యూ షుడ్ హ్యావ్ ది అప్రహెన్షన్. దట్ మీన్స్ ఇట్ ఈస్ అప్రహెన్షన్ అంటే రీజనబుల్ అప్రహెన్షన్ దట్ యు ఆర్ గోయింగ్ టు యూజ్ ఫోర్స్. So this is what is called assault. So what is force? Already I told you, 319 of the Indian Penal Code. Force means change of motion or cessation of motion. అంటే ఉన్నదా మనిషిని నెట్టేయటం లేదా వెళ్ళేవాడిని ఆపడం ఆర్ all these things they constitute the force. So if force is used, జాగ్రత్త అండి, ఇక్కడ ఇండియన్ పెనల్ కోడ్కి వచ్చేటప్పటికి క్రిమినల్ ఫోర్స్ అంటారు దాన్ని. క్రిమినల్ అంటే దేర్ షుడ్ బి సమ్ ఇంటెన్షన్. లేకుండా ఫోర్స్ చేస్తే, సపోజ్ ఎవరో మీకు అడ్డం వచ్చారు, పక్కన నెట్టేసారు అనుకోండి, ఇట్ ఈస్ ఆల్సో ఫోర్స్, బట్ ఇట్ ఈస్ నాట్ క్రిమినల్ ఫోర్స్. యూ వాంటెడ్ టు పుష్ హిమ్ అసైడ్, దట్స్ ఆల్. So it's not a crime. అది గుర్తుపెట్టుకోండి. Right, so please remember, when the defendant by his act creates an apprehension, that apprehension in the mind of the plaintiff that he is going to commit the so-called use the force, or actually that is battery. So if you are about to use force, then it is called assault. So don't get confused. Show of force is assault. Use of force is battery, simply to say. So very simple definition is that. So here, if you show a loaded pistol to another person, is it assault or battery? Definitely assault. If you fire at him, it is battery. So this is the difference. Please remember. So showing a loaded pistol, definitely it is assault, right? So there are two important already 5 minutes. So it's please remember there should be some ability for the defendant to cause the harm, right? Suppose you are standing at a different long place, and if you show your hand like this, it cannot be battery, even it cannot be so-called assault also. So therefore already I have given the examples also. You may be knowing, I that notes lo board ఉన్నాయి. క్లెంచింగ్ ఫిస్ట్ అంటే కేవలం మామూలుగా నేను ఏం మాట్లాడకుండా పళ్ళు బిగించినా సరే, ఇట్స్ ఆల్సో అసాల్ట్, బికాస్ ది అదర్ పర్సన్ విల్ హ్యావ్ ది అప్రహెన్షన్ దట్ యు ఆర్ గోయింగ్ టు యూజ్ ఫోర్స్, దట్ ఈస్ అసాల్ట్. అది కొంచెం గుర్తుపెట్టుకోండి. సో ప్లీజ్ రిమెంబర్, it should create an impression in the mind of the person that you are going to use force, right? Then there are two important case laws. If you know them, that is sufficient. The one is famous, BALISETTY Venkata Surya Rao versus Nadipati Muthiah, 1964 అనుకుంటాం. 1964. So BALISETTY Venkata Surya Rao is a very good landlord in the village, and Nadipati Muthiah, he is the village munsif. As village munsif, he has got duty collect revenue cess. On one particular day, he visited the village of BALISETTY Surya Rao, and he was collecting money. Incidentally, he came to the house of Surya Rao also and asked him to give money. But ఇతను దరిద్రం ఏంటంటే, his wife went away locking the house, and she will not come for within a couple of days. He expressed his inability. అరే నీకు డబ్బులు ఇవ్వాలి ఎంత, I think it is 11 rupees, I believe, if I am correct. So yes, this man Nadipati Muthiah, who is the village munsif, he visited the village residence of BALISETTY Surya Rao on 31st March 1956, and to collect rupees 11.60. Why 31st March I have specifically mentioned is, normally it is the end of the year, end of the financial year. So last days లో కలెక్టర్ గారు లేకపోతే తహసీల్దార్ ఎవరికి హడావుళ్ళు ఉంటాయి, అందుకని ఆ డేట్ నీకు చెప్పాను. అదర్వైజ్ డేట్ ఈస్ నాట్ ఇంపార్టెంట్ ఇన్ దిస్ పర్టికులర్ కేస్. సో ఇతని టెన్షన్ కూడా యూ హ్యావ్ టు అండర్స్టాండ్. ఇతని మున్సిపల్ గారి టెన్షన్ ఏంటి? హీ హ్యాస్ టు కలెక్ట్ ద మనీ, ఇస్ ఇట్ నాట్? రెవెన్యూ సిస్, బట్ హిస్ వైఫ్ ఈస్ నాట్ దేర్, హీ కెనాట్ పే ద మనీ. హీ ఈస్ అ రిచ్ ల్యాండ్ లార్డ్ ఇన్ ద విలేజ్, వాట్ ఎవర్ ఇట్ ఈస్. ఎంత పెద్దవాడికి డబ్బులు లేనప్పుడు ఏం చేస్తాం? సో ఆల్రెడీ సమ్ ఆల్టర్కేషన్ టుక్ ప్లేస్ బిట్వీన్ దెమ్. ఆల్మోస్ట్ గొడవలాగా అయిపోయింది. ఇతను ఏమని అంటాడు, నువ్వు కడతావా లేదు అన్నాడు. సో అల్టిమేట్లీ ద విలేజ్ మున్సిఫ్ told him that he is going to impound the gold earrings hanging to the ears of BALISETTY Venkata Surya Rao. Then he asked the village servant to go and bring or fetch that goldsmith to remove the so-called earrings. So when the situation has become so grave, so some of the villagers, the known persons or relatives, they came to the rescue of BALISETTY Surya Rao and paid the money. So of course the goldsmith came, but he did not do anything. He was just waiting outside. Since the issue has been settled, munsif and all the people went away. But aggrieved by the attitude of the munsif, this man BALISETTY Venkata Surya Rao, he filed a case of assault on the village munsif. But please remember, it was held that the defendant, please remember, the defendant after the arrival of the goldsmith said nothing and did nothing, because already the money has been paid. So therefore there is a remote possibility of removing or to have put the plaintiff in the fear of instant or immediate violence. సో దర్ ఇస్ తీస్తానన్నాడు. వాడికన్నా ట్రై చేసి ఉంటే డెఫినెట్గా ఇట్ కుడ్ హ్యావ్ బీన్ అసాల్ట్. సో దేర్ ఫోర్ ఇట్ ఈస్ నాట్ అసాల్ట్. ప్లీజ్ రిమెంబర్. సో అఫ్ కోర్స్ అందుకని మీకు చెప్పాను, ఎవ్రీ కేస్ డిపెండ్స్ ఆన్ ది ఫ్యాక్ట్స్ అండ్ సర్కమ్స్టాన్సెస్. ఇక్కడ ఈ కథ చెప్పాలంటే దాదాపు మీకు అరగంట పడుతుంది, బట్ సింప్లీ టు సే దిస్ ద థింగ్ హ్యాపెన్. So another case is important. Stephens versus Myers. It is happening in 1830, very old case. So in this case, actually Stephens was the chairman in a parish meeting, Christians meeting, and they were holding the meeting. Of course, Mr. Myers is also an executive member. He sat on the table. Of course, he sat on the last table. So there were heated exchange of words. And actually in between the Stephens, who is sitting in this chair like this, and Myers, there were 6 or 7 people. All of them are directors or some executive members. They are also sitting at the same table. Right? In the course of some angry discussion, please remember, normally at the time of meetings you can be observed. In the take of angry discussion, the defendant has been vociferous. That means Telugulo మాట్లాడుతున్నాడు అంటే భయంకరంగా మాట్లాడుతున్నాడు. And he interrupted the proceedings of the meeting. జరుగుతూ ఉంది, వసిఫెరస్ వాక్, ఏది పెడితే అది మాట్లాడుతుంటారు కదా. మనకు కూడా క్లాసులు జరిగేటప్పుడు ఏదో ఒకటి మాట్లాడుతుంటారు. సో అలా మాట్లాడుకుంటూ ఉంటాం, మంచిది. బట్ అయినా మాట్లాడడం మనం ఏం చేయలేం. సో a very large majority is decided that the defendant better be expelled from the meeting. ఏమిటిది న్యూసెన్స్ కలుగు చేస్తున్నాడు, మాట్లాడితే ఏదో ఒకటి అడ్డం తగులుతున్నాడు, బెటర్ తీసేస్తే పోద్దాం అని చెప్పన్నారు. కానీ సరే జరగనీలే, అతను కూడా ఎగ్జిక్యూటివ్ మెంబర్ కదా, జరగనీలే జరుగుతుంది. ఈ లోపల హీటెడ్ వర్డ్స్ హ్యావ్ టేకెన్ ప్లేస్. లాస్ట్ ఇది ఇంపార్టెంట్ వెన్ ద డిఫెండెంట్ అడ్వాన్స్డ్ టువర్డ్ ద చైర్మన్ విత్ ఎ క్లెంచ్డ్ ఫిస్ట్. క్లెంచ్డ్ ఫిస్ట్ అంటే బిగించాడు, పిడికిలు బిగించాడు. హీ వాజ్ అడ్వాన్సింగ్ టు ది చైర్ పర్సన్, స్టీఫెన్స్ మీదకి వెళ్ళిపోతున్నాడు. దెన్ సమ్ ఆఫ్ ది పీపుల్ actually saying that he clenched his fist and he said that he would rather pull the chairman out of the chair than be turned of the room. మరి నువ్వు పోరా బాబు అంటే వాడిని కుర్చీలోంచి లాగా పడేసి వెళ్ళిపోతానని చెప్పి గందరగోళం చేస్తున్నాడు. బట్ ఎనీవే, బట్ he was stopped by the church warden. He was stopped by the church warden who was sitting just by the side of this Stephens. సో ఆయన అక్కడ కూర్చున్న చర్చ్ ఆయనండి నెట్టేశాడు. సో దిస్ ఇస్ సో whether it is assault or not. Now Stephens filed a case of tort against him, against Myers, that is assault. Whether it is assault or not. Generally, please remember, assault precedes battery. Here, the apprehension, the fist clenching of the fist, and saying that he would rather pull him out of the chair. So, showing a clenched fist itself is an assault. But please remember, if he had used the fist against the so-called Stephens, it would have become battery. That's all. So definitely it is. And please remember, I gave an example. Of course, next only I have the battery low chapalmidi. If the chair is pulled, if the person falls down, it is also battery, not assault. Endukante manishi injury jarugutadi kabatti. So please remember, all assaults are not batteries, but battery will definitely include assault. So we'll discuss that. Our topic as far as this thing is concerned, it is sufficient. So please do remember these 2 important cases. ఏమేంటవి? బాలిసెట్టి వెంకట సుబ్బారావు వర్సెస్ నందిపాటి ముత్తయ్య 1964 and Stephens versus Myers. So with this we are stopping. This is regarding assault. So please study the notes. Definitely you will be able to understand. So you may not be so fluently speaking or fluently writing. You can write in your own English language, no problem. Right? Thank you very much.